What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. You've heard all this before. We have major updates in the Poppy versus Mars Argo lawsuits. I guess more appropriately, Brittany Alexandria Sheets versus Corey Michael Mixter, Titanic Sinclair Productions, Mariah Rose Pereira, and I Am Poppy Incorporated. Okay? They have, presumably, according to court filings, reached a settlement. If you don't remember what the status is, we've been in limbo for a very long time because it appeared that Miss Sheets had not actually served Poppy or Titanic Sinclair in time. I cannot verify that she ever actually served them. We know they found out about it. It was news in all of the channels that they would be watching. Their fans were talking about it. So they released some videos and music that indicated that they had information about the lawsuit. So they were aware of it for sure. And they probably had read the documents and probably given them to their lawyer. If we're being honest, that all that likely happened. However, federal rules of service are strict. And it appears that Brittany Sheets did not ever properly serve them. Now, there are all sorts of reasons to not serve someone. Some of those reasons are you talked to them, you said you're going to file a lawsuit, and what you did was you entered negotiations, and you can enter negotiations and get permission, either written in long form or by email, to say, can we have an extension on filing an answer or on filings or on service? Can we have an extension on any of these things? You can mutually agree to that. So Sheets may have filed the lawsuit, contacted them, and said, look, I don't want to serve you if we can resolve this outside of court. This may be what happens. The other thing that may have happened, which would be really important as well, would be if you, or if Sheets failed to serve Mixter and Mariah Pereira, if she had failed to serve them, as it appeared she did, they might have contacted her and said, listen, we will file to have this action dismissed, or we can work this out, but you're going to be at a disadvantaged bargaining position would be the implied sort of settlement negotiation there. So the unfortunate thing is that when there's a private settlement, we may not ever see the details, but here is what we know so far. We'll go through this very quickly. So this is the notice of settlement. This is filed by Brittany Alexandria Sheets. So she says, to the court, all parties and their attorneys of record, please take notice that plaintiff Brittany Alexandria Sheets, by and through her attorneys of record Spertus, Landis, and Umhofer, LLP, and defendants Corey Michael Mixter, an individual, aka Titanic Sinclair, Titanic Sinclair Productions Incorporated, a California corporation, Mariah Rose Pereira, an individual, aka Poppy, aka That Poppy, aka I Am Poppy, and I Am Poppy Incorporated, a California corporation, by and through their counsel of record, Kinsella, Weitzman, Iser, Kump, and Aldisert LLP, have reached a settlement in principle and anticipate that a settlement agreement will be authorized and executed within 30 days from the filing of this notice. Accordingly, given this status, the parties jointly request that the court continue all dates in this matter, including any deadline for defendants to answer or otherwise respond to the complaint by 30 days or a date thereafter convenient to the court. So, these guys have reached settlement. What happens once you reach settlement is you're sitting in a room or you're exchanging emails and you say, listen, I'm going to give you this much money and you're going to take down this many videos, for example. And then you say, okay, we agree on that. In principle, we agree 100%. Then you ruin everything by getting lawyers involved to draft up a contract, a representation of that contract, that everybody agrees on, and that part takes time because lawyers have to email back and forth. We have to get agreement. We have to make sure that you really don't like that idiot's use of the word the in the third paragraph, so you got to get that lined out, and they have to bicker about it. There's a back and forth that happens in the drafting and adoption of the document before it actually gets signed by the parties and presented to the court as proof that they have reached settlement, okay? So that's what we're in right now, is this holding period. Here's the court has ruled. Very short response. The court, having been advised by the counsel for the parties that the above entitled action has been settled, it is therefore ordered that this action is hereby dismissed without costs and without prejudice. So, prejudice to the right upon good cause shown within 45 days to reopen the action if settlement is not consummated. Okay. Let me break that down. So everybody's responsible for their own attorney's fees. This is very important for the parties. The 45 days good cause means that if you guys are reaching settlement, you've told the court that you've reached settlement. So you have 45 days to go ahead and say, actually, settlement talks broke down, so now we need to go back to the action. And you need to have a good reason for the settlement talks to have broken down. Not just, well, we didn't actually agree. No, you did agree, but maybe one party was arguing in bad faith or something like that. Otherwise, 45 days from the filing, which was September 14th, which I think was Friday, 45 days from September 14th, this action will be gone. It will be dismissed. It will be changed to dismissed with prejudice at that point, because the parties have reached an outside agreement, and that is how most of these things end up. We may never know the details. I'm sure the fans of Poppy will be out there watching to see what videos of hers might come down, what statements she might make in an upcoming video, if Mars Argo gets promotion through either of their brands, gets incorporated back into the group. All of these things are possibilities within the settlements. But unless they file a document specifically laying that out, we won't know. We won't know. But you can put your internet autism to the test. You can, if you guys are fans of these people, see if you can notice any major disparities in what's out there now versus what will be out there at the end of this 45 days. If videos start dropping down, like you might see that Doritos Monster Energy drink video drop down, that might be part of their agreement. The other reality is that it could be a behind-the-scenes deal where they simply pay a percentage of profits to Mars Argo. And they say, look, yeah, maybe this one was your idea. And for that, what we're going to do is on this video where it looks like we might have taken some of your idea, we're going to give you X amount of dollars. We can use YouTube analytics to find out exactly how much the video made, and we're going to give you X amount of dollars from that. So that could be the solution. If that's the case, we may never know any of the details. But we'll see. Both parties have an opportunity to now use this to propel themselves forward in ways that will relaunch the Mars Argo brand and will allow Poppy and Titanic Sinclair to make of this instance what they will. They can generate content off of this lawsuit. They can talk about how Poppy had to learn the system of laws, because the whole idea is that Poppy doesn't understand, I think, the reality that she's living in, and excoriate me for that if I'm wrong about it. But she's this being that has transcended our reality in some way, and so she is not fully aware of how everything works. So she's kind of experiencing everything for the first time, and there's been a lot of speculation that was kind of a plan from the start, and maybe it was. Well, we probably will never know. But if they had wise attorneys involved in this, this would have been a very expensive way to do that. But if they have wise counsel and good advisors, they can make it into that and still use this as a platform for content and for acquiring attention and fans. And that's usually a good way to use this. I'll go through this copyright document real quick. This just lists the 3 major videos. This is going to mean more to any of you than it will to me, because I don't know specifically what works these are. But here are the 3 works that are at issue in this lawsuit. We've got Linden Place EP, Love in Black and White EP, and Technology is a Dead Bird. So those are the 3 copyrighted works that are in question in this lawsuit. Of course, the lawsuit is being dismissed, so it doesn't really matter. This report is just a determination that action has occurred about the authorship of the work or who owns the work. So that's where they're at. But again, this is being dismissed because the parties have come to an agreement. They may refile the copyright with regard to these 3 properties and properly reflect who the author is. Not sure how that'll work out, but you know, if you follow them, you might be able to get some information out of those 3 titles. So hopefully that helps you all understand where Poppy and Mars Argo are. It is the slow, silent death of a lawsuit. We will probably never get the details. If we get any details or public statements, I will gladly comment on them. But for now, it looks like we have some more silence coming. But that silence is a resolution to what has gone on. So thank you all for watching. Have a great night. If you have any questions, drop them in the comments. Peace.